My name is Michael Sheridan and I am Secretary to the Scottish Law Agent Society. I am speaking to you during the month of March 2010, during which month our Society has requisitioned a special general meeting of the Law Society of Scotland in order to consider the retention of the long-standing prohibition on external ownership of legal practices. The question as to whether non-solicitors should be allowed to own legal practices was never an issue in Scotland until about 6 years ago, when the Clementi report in England and Wales recommended the authorisation of non-legal ownership in that jurisdiction. The whole concept was unanimously rejected around the Scottish legal profession until May 2008, when a somewhat vaguely worded motion was passed at the Law Society annual general meeting that year, on the back of 600 plus proxies addressed to the same 4 large legal firms. This resolution, however, was then taken up by the Scottish Parliament as being representative of the whole Scottish legal profession, and we now have the Legal Services Bill, which proposes to open up the ownership of legal practices to non-solicitors. However, when our own society conducted an opinion poll during 2009 and received in excess of 400 responses, that response indicated a 75% rejection of alternative business structures in principle and an 80% rejection in specifically of external ownership of legal practices. For that reason, our society has decided to call for a special general meeting to enable the wider profession to debate the issue and to come to a considered and principled verdict as to whether or not the external ownership of legal practices ought to be permitted. In the meantime, the Justice Committee of the Scottish Parliament has indicated that it will hold up further progress in the bill until such times as it has had an opportunity to consider the outcome of our special general meeting. One thing is beyond doubt: our special general meeting has sparked off an enormous debate around the whole profession up and down the country, and has led to an increasing number of solicitors considering very closely the fundamental principles of the profession and the principles of the provision of justice. There's a great deal of information concerning these issues on this website, and in this short introduction I want to make 3 simple points. In the first place, one has to appreciate the enormous financial implications of this bill. At present, the owners of the equity in a large law firm have only a very restricted market in which those interests can be sold, and of course the smaller the market, the smaller the price. If the Legal Service Bill progresses, then the size of the market will be virtually unlimited, and likewise the value of asset will similarly increase. Those individual owners of that equity stand to substantially increase their wealth on the back of this bill. My concern is that the conversion of the fundamental values of the legal profession into monetary value must inevitably detract from the true core value of the profession. In other words, it turns an essential professional service into a marketable commodity. The second point I want to make concerns the fitness for ownership test. It is said that any threat of irresponsible or inappropriate ownership of legal practices shall be avoided by virtue of the fitness for ownership test. So that any person becoming an owner of a legal practice shall have to pass that test. Well, in the first instance, I'm not sure how the test would be applied, for example, to shareholder owners. However, put that aside. In my mind, the fitness for ownership test is a complete illusion. In this day of anti-discrimination, once a criminal has served his time or paid his fine, he's entitled to be treated the same as anyone else. In this day and age, once a bankrupt obtains his discharge, is entitled to be treated the same as anyone else. If any person or body makes a subjective, judgmental decision that some other person's not fit to own a legal practice, that's extremely unlikely to stand up to scrutiny in the courts. However, we do have a fitness for ownership test. It's long and well established. In order to become fit to own a legal practice, you first of all acquire a thorough knowledge of the law. It takes 3 or 4 years, usually at university. You then do your diploma in legal practice, costs you up to £4,500 unless you're one of the lucky few that gets it paid for you. You then do a 2-year traineeship, during which time you have to pay for a professional competence course, £1,500 approximately, unless you're lucky enough for your employer to pay it for you. You then serve 3 years as a qualified assistant, and you attend the Law Society course in being a principal solicitor. That 9, 10 or 11 year process makes you fit to own a legal practice, not handing over a pile of money. The third and last point I want to make in this short introduction is to emphasise that this whole issue concerns the private legal practitioner. It has absolutely no bearing upon the status or regulation of the in-house solicitor at local authorities, Standard Life or some other big concern, or the Crown Office and Procurator Fiscal Service. Those solicitors are fully regulated, fully authorised, and there is no issue with them whatsoever. Any suggestion that our motion in any way impinges upon those solicitors is quite wrong, unfounded, and even false. Well, now, as we approach our special general meeting, the eyes of Parliament and of the country are focused on the legal profession. Our society hopes to present a debate, a consultation and a considered and principled decision-making process for which all our members and the wider profession may be proud.